beaucoup, M. Chung. Nous entendrons à présent M. McSorley.
Merci beaucoup, Monsieur le Président. And thank you for the invitation to appear here today on behalf of our coalition of 46 Canadian organizations. We recognize the importance and the urgency of addressing the impacts of foreign interference, particularly where governments are threatening individuals or their close ones in order to repress their ability to exercise their fundamental rights or engage in democratic processes. I'm also very cognizant and grateful for the efforts that have gone into this committee, holding multiple and even marathon meetings throughout this week. However, I must share that I, the coalition I represent, and my colleagues at other civil liberties and human rights organizations are deeply troubled by the rushed process that this bill has taken. A bill of such breadth requires in-depth study. Introduced barely a month ago with the foreign interference inquiry ongoing, it will have gone through committee study in both chambers of Parliament in just 2 weeks. This is faster than the 2001 study of the first Anti-Terrorism Act, which was granted consideration over a period of 2 months. This expedited study means that experts and organizations with limited resources have had to rush their analysis of the bill and has made submitting briefs and appropriate amendments nearly impossible. Bill C-70 is a very consequential bill that deals with crucial issues that are important to the protection and promotion of democracy and democratic rights in Canada. It also has the potential to uphold those rights, but also contains very clear areas where those very rights may or will be undermined. We fear that those concerns will remain unaddressed until after C-70's provisions are implemented and their impact felt by individuals and communities across Canada. We're therefore urging the committee to work with your fellow senators to extend your study of Bill C-70 in order to hear more input and analysis and to provide the opportunity to develop, propose, and debate amendments. In what ways are the changes in Bill C-70 consequential? It has been presented as legislation to address the important threats of foreign interference, but the changes proposed to this legislation also go much further. If adopted, Bill C-70 will have wide-ranging impacts on Canada's national security, intelligence, and criminal justice system. As such, it will also have significant impacts on the lives and fundamental rights of people in Canada. This includes growing surveillance, diminished privacy, and increased racial, religious, and political profiling. Other provisions contain undefined or overly broad wording that could infringe on freedom of expression and association, along with proposed punishments that raise significant questions of proportionality in sentencing. The way courts handle sensitive information will also change, undermining due process in the justice system through the use of secret evidence. I'd like to share some of our specific areas of concern. First, modifications to CSIS's dataset regime are only tangentially related to foreign interference. Many of these changes actually arise from a scathing National Security and Intelligence Review Agency report that found CSIS had been breaking the law in its implementation of the dataset regime. Instead of ensuring an adherence to the law is being modified to legalize CSIS's activities. The potential consequences of these changes remain unclear and should have been addressed during a statutory review of 2019's National Security Act. We'd recommend removing these changes until such a review can happen. We are also concerned by changes to disclosure powers in Section 19 of the CSIS Act. While we understand the goal and the importance of ensuring appropriate information can be shared, serious questions have been raised over the past 2 decades around how CSIS has handled the disclosure of sensitive information. Subsections 34.2 and 34.3, clauses 34.2 and 34.3 of C-70 in particular require greater safeguards. C-70 also grants CSIS significant new production order and warrant powers. It comes after years of courts admonishing CSIS for misleading them in their warrant applications. Warrant requirements exist to protect our rights. They shouldn't be lessened right now, and especially not while CSIS's problems of breaches of duty of candor to the courts have not been properly addressed. This bill also changes the Security of Information Act to create new rules that would see minor offenses, if committed in association, which remains undefined, with a foreign entity, be punishable by either life in prison or consecutive sentences that could amount to life in prison, raising concerns of proportionality in sentencing, as well as freedom of expression. We also have concerns about the proposed foreign influence registry and new sabotage offenses, including a very troubling amendment adopted in the other place this past Monday. But I'd like to conclude just by commenting on changes to the Canada Evidence Act. Our coalition is fundamentally opposed to expanding the use of secret evidence in Canada's courts under the guise of protecting national security, national defense, and international affairs. Introducing a standardized system for withholding information from those challenging government decisions will normalize this process and will facilitate the spread of the use of secret information further into our justice system. Thank you very much for my time today, and I really look forward to discussing this with you further.